Ladies and gentlemen, good evening. It's an absolute pleasure to welcome you to this, the 18th consecutive annual lecture in the Barrister Syed Ishtiaq Ahmed Memorial Lecture Series. I'm delighted to introduce to you Barrister Manzoor Hasan OBE and Executive Director, Center for Peace and Justice, BRAC University, as today's invited speaker.
Thank you. Thank you very much, Dr. Justice Syed Rifat Ahmed and Professor Muhammad Humayun Kabir, distinguished guests, ladies and gentlemen, and representatives of print and electronic media. Good evening to you all. Due to unforeseen situation, we had to move to a hybrid platform. So let me greet those who have joined us online. Thank you, Dr. Justice Syed Rifat Ahmed and Professor Humayun Kabir, for your warm welcome and kind words. I am thankful to the Asiatic Society of Bangladesh for giving me the opportunity to deliver the Barrister Syed Ishtiaq Ahmed Memorial Lecture 2022. Let me commence by sharing with you a very personal recollection. When I returned to Bangladesh in 1985, after being called to the bar, I sought advice from my father-in-law, late Mr. Justice Abu Said Chaudhry, on my pupillage. He instantly replied, "Your pupil master will be Barrister Ishtiaq," as he was my pupil when he returned from the UK as a young barrister. The rest is history, as they say. The next 2 years were for me incredibly foundational. I vividly remember and recall his intense affection and warmth. I feel extremely fortunate that I've been requested to deliver this lecture in memory of my pupil master, Barrister Syed Ishtiaq Ahmed. As a legal practitioner in the UK and Bangladesh, I have dealt with various refugee issues emanating from different countries of the world: Sri Lanka, Lebanon, former Yugoslavia, Cyprus, Libya, Uganda, and more recently, Myanmar. This lecture very much falls back on my experience of legal and socio-political considerations related to refugees generally, and more particularly to the application or non-application of the 1951 Refugee Convention and its 1967 protocol. I'm grateful to the Trust Management Committee of the Barrister Syed Ishtiaq Ahmed Memorial Foundation for providing me with this platform to share some of my reflections on the theme of Bangladesh and the protracted Rohingya refugee obligations, a future pathway. Let me mention at the outset that I have moved away from the prepared and printed lecture which has been sent to you. The printed lecture refers to acts, sections, and citations and can be useful reference document. Hopefully, what I'm about to deliver will be more listener-friendly. There is also a PowerPoint which will be presented as I speak. In this lecture, I will assess some of the rights that the Rohingya may have in Bangladesh under the various global, regional, and national legal instruments. And in light of that, I will tentatively present some key recommendations for policymakers to consider when dealing with the protracted presence of the Rohingya in Bangladesh. Before I do so, let me briefly provide the historical backdrop of the Rohingya influx in Bangladesh and the reasons for these mass displacements. Shoot all you see and all you hear. After receiving this order from his commanding officer in August 2017, Private Mo Win Tun confessed in a video confession years later to have participated in the killings of 30 Rohingya Muslims and burying them in a mass grave close to a cell tower and a military base. If nothing else, the preceding confession should make abundantly clear the horrific life that the Rohingya were forced to live in Myanmar. In fact, less than 1 million Rohingya have fled to Bangladesh since August 2017 to avoid detention, torture, rape, and other grave human rights violations after a clearance operation conducted by the Myanmar military. The Rohingya have faced decades of systematic discrimination, statelessness, and targeted violence. Thus, quite understandably, the forced migration of Rohingya to neighboring countries, including Bangladesh, is not a new phenomenon in this part of the world. When the Rohingya were conquered from the Muslim-dominated Kingdom of Arakan in 1784, they were integrated into the majority Buddhist Kingdom of Burma. During that time, a large number of Rohingya refugees fled to Cox's Bazar. During the 1800s, after a series of invasions, Britain colonized Burma, and the British moved people between Burma and East Bengal to fulfill their need for labor. Communal riots between Rakhine and Rohingya villagers in Rakhine state escalated in 1942 as a result of Japan invading Burma and Britain withdrawing, causing an estimated 22,000 Rohingya to flee into East Bengal. After Burma gained independence in 1948, unrest between the government and the Rohingya further escalated. In 1962, the Burma Socialist Party came to power and dismantled Rohingya social and political organizations. In 1977 and 78, more than 200,000 people fled to Cox's Bazar after being evicted from their homes in Rakhine state by the Myanmar military. This is widely recognized as the first major wave. The 1982 Burma citizenship law further complicated the matters by denying the Rohingya all form of citizenship. Under the provisions, children born to non-citizens were denied Burmese citizenship as well. Due to their lack of full citizenship rights, the Rohingya were vulnerable to a wide range of abuses, including limits on their freedom of movement, discriminatory barriers to education, and arbitrary property confiscation. When the Myanmar military increased its presence in Rakhine state in 1990, an estimated 250,000 Rohingya fled to Bangladesh. Again, over 87,000 Rohingya crossed into Bangladesh in October 2016 as a result of an upsurge of insurgent activity along the border and subsequent military operations. However, the biggest influx occurred in 2017, and as it stands today, Bangladesh is housing Rohingya as forcibly displaced Myanmar nationals, FDMN, instead of refugees. It could also be mentioned here that Bangladesh, and in particular Cox's Bazar, is hosting one of the largest refugee camps in the world, where the refugees outnumber the local population. It may be appropriate here to provide a snapshot of some of the most important global statistics concerning refugees. According to UNHCR, the world now hosts approximately 32.5 million refugees, with low and middle income countries hosting approximately 74% of world's population, world refugee population. 72% of them originate from just 5 countries: Syrian Arab Republic, Venezuela, Ukraine, Afghanistan, and South Sudan. And 36% are hosted by 5 countries: Turkey, Colombia, Germany, Pakistan, and Uganda. One final statistics for you: 1.5 million children were born as refugees between 2018 and 2021. I move on to the next section, which is rights under the Constitution of the People's Republic of Bangladesh. Bangladesh is very well aware of the sufferings of refugees, as its own people have experienced the horror of being forced to flee their country to escape torture and mass killing. Following the landslide victory of Awami League in the 1970 election, West Pakistani leaders began procrastinating, which resulted in unprecedented human suffering. On the night of March 1971, the Pakistani military launched its Operation Searchlight against the unarmed civilians of East Pakistan. Thousands of people died in the first few days. and an estimated 10 million people fled from Bangladesh, crossing the border and seeking refuge in India, while 30 million were internally displaced. This harrowing experience has stayed with the people of Bangladesh, and the country has opened up its border to the Rohingya many a times. The Bangladesh Constitution protects not only its citizens' fundamental human rights, but also non-nationals living within Bangladesh's borders. The Constitution identifies 18 fundamental rights. The majority of these rights are applicable to Bangladeshi citizens only, but some rights are available to both citizens and non-citizens. It is also important to note that no provision of any law may be in conflict with constitutionally guaranteed fundamental rights. In other words, both citizens and non-citizens have been afforded significant constitutional protection, a point that is often forgotten. Let me now focus on determining the status of the Constitution in relation to global laws. The Constitution of the People's Republic of Bangladesh mentions international law twice. First, Article 25 states, and I quote, "The state shall base its international relations on the principles of respect for international law and the principles enunciated in the United Nations Charter." End of quote. Then Article 145A states, and I quote, "All treaties with foreign countries shall be submitted to the President, who shall cause them to be laid before Parliament." End of quote. However, Article 7, sub-article 2 clearly states that the Constitution is the supreme law of the Republic, and thus it overrides both national and international law. But what happens when national and international law clash? In such a situation, national law prevails over international law. Furthermore, international treaties will only be enforceable in national courts once their provisions have been incorporated into domestic legislation in Bangladesh. Move to the next section, which is rights under municipal laws. Bangladesh is not a signatory to the 1951 Refugee Convention and the 1967 Protocol, as I've mentioned before. These are the main international legal instruments governing refugee rights. Also, Bangladesh does not have a specific domestic law or national policy dealing with the protection of refugees. In Bangladesh, refugees are predominantly governed by the Foreigners Act 1946. It outlines the rules for the entry, stay, and departure of foreign nationals. It should be pointed out that Section 10 of the Foreigners Act gives the government considerable power to exempt any individual foreigner or any class or description of foreigners from any provision of the Foreigners Act. So far, the Rohingya are being treated as foreigners in Bangladesh under this law. There are also a number of acts that not only apply to citizens, but also to people who are within the territory of Bangladesh. These acts could be applicable to the Rohingya in Bangladesh, allowing them to have access to a wide range of services, including birth and death registration, marriage, and custody of children. However, I believe that there is a lack of clarity as to whether and how these laws will be applied to the Rohingya. Bangladesh had the political will to allow the Rohingya to enter Bangladesh in 2017 and in earlier years, when they faced horrendous persecution in Myanmar, and the whole world applauded the magnanimity and generosity of Bangladesh and its citizens. I would say that we as a nation have another opportunity to extend to the Rohingya a favorable application of these laws, which will further strengthen our high moral position in the Committee of Nations. This will nevertheless require cooperation and support of our friends in the region and globally. I will discuss this further later. Let me continue. Furthermore, there are judgments from the Supreme Court of Bangladesh that come within the scope of this discussion. In the case of Refugee and Migratory Movement Research Unit and Bangladesh, the court ruled that due to Bangladesh's non-refoulement obligations, the return of a Rohingya individual to Myanmar was not possible. More importantly, the court stated that the 1951 Refugee Convention has become a part of customary international law that is binding upon all countries of the world, regardless of whether a particular country has formally signed, acceded to, or ratified the convention or not. However, I believe the practical implication of this judgment is yet to be seen in the current context. Nevertheless, as a non-signatory state, Bangladesh has taken many significant steps over the last few decades by creating what academics term soft laws to protect refugees by promoting creative solutions. I move to the next section, which is rights under global legal instruments. The 1951 Convention and its protocol are the main international legal instruments concerning refugee rights, as I've noted before. Bangladesh has not ratified the 1951 Refugee Convention and its 1967 protocol. However, this does not mean that the Rohingya living in Bangladesh do not have any right under international law. In fact, many of the same rights that are enshrined in the 51 Convention and 1967 protocol are also ingrained in other international human rights instruments that Bangladesh has signed and ratified. Although it is not possible to discuss all of the rights that refugees have under these instruments today, some of the key provisions must be mentioned as examples. Article 3 of the Universal Declaration of Human Rights protects the right to life, liberty, and security of a person. And again, this is found in our constitution as an annexure to the constitution. Article 14 of UDHR protects right to seek and enjoy in other countries asylum from persecution. And Article 26 of International Covenant on Civil and Political Rights guarantees rights to equality before the law and equal protection of the law. I move to the next section, which is international justice and accountability and Bangladesh's leadership role in this particular matter. 3 international institutions and their involvement with the Rohingya issue could be highlighted in the context of international justice and accountability. The International Court of Justice is one of the 6 principal organs of the United Nations. It settles disputes between states in accordance with international law and gives advisory opinions on international legal issues. The Gambia has established a very high international legal and moral standard by bringing a case before the ASB in The Hague in 2019, accusing Myanmar's military of, and I quote, conducting extensive and systematic clearance operations, unquote, against the Rohingya, committing mass murder, rape, and village torching with the intent to destroy the Rohingya in whole or in part. Regardless of the outcome, Akila Radhakrishnan, president of the Global Justice Center, was right in pointing out that the decision was an enormous step, and I quote, an enormous step forward for justice. It sends a signal to Myanmar's military that they cannot commit atrocities with impunity. The case proceeding is all the more important in light of the February 2021 coup, which was enabled and emboldened by the impunity the military has been afforded for far too long, end of quote. Bangladesh welcomed the International Court of Justice verdict. A foreign ministry press release stated, and I quote, Bangladesh maintains that the question of international justice and accountability will be critical in finding a durable solution to the Rohingya crisis, and would also prove to be a confidence-building measure for the sustainable repatriation of the Rohingya to their homes in Myanmar with their legitimate rights restored, end of quote. Prior to the ICJ proceedings in 2019, the International Criminal Court in The Hague took a bold step. On 4th of July 2019, the Office of the Prosecutor of the ICC requested authorization to initiate an investigation into crimes within the court's jurisdiction, in which at least one element occurred on the territory of the People's Republic of Bangladesh, a state party to the Rome Statute. The ICC investigates and, where warranted, tries individuals, not state, individuals, charged with the gravest crimes of concern to the international community. They are genocide, war crimes, crimes against humanity, and crimes of aggression. On 4th November 2019, the ICC judges granted the office of the prosecutor's request to start the investigation. In reaching this groundbreaking decision, the judges also took into account the victims' representations introduced on behalf of more than 500,000 Rohingya, who all supported the opening of the investigation. And I'm sure many of the participants today have been involved with this representation that was put before the ICC. The ICC has now started the investigation in relation to any crime, including any future crime, as long as the ICC has the power to deal with such a crime and the crime is allegedly committed, at least in part, on the territory of Bangladesh. It is important to note the fact that the ICC could start the process because of Bangladesh's ratification of the Rome Statute, and that Bangladesh has provided generous support to the ICC from the very outset of the process. Global support for justice and accountability in Myanmar is also highly visible, and Bangladesh's diplomatic role needs to be recognized and applauded in this context. In addition to the ICC, the UN's independent investigative mechanism for Myanmar, known as IIMM, was established in September 2018 by the UN Human Rights Council. IIMM has the mandate to collect, consolidate, preserve, and analyze evidence of the most serious international crimes and violation of international law committed in Myanmar since 2011. It is further mandated to prepare files in order to facilitate and expedite fair and independent criminal proceedings in national, regional, or international courts or tribunals that have or may in the future have jurisdiction over these crimes. The Human Rights Council was responding to reports, including those by the UN Independent International Fact-Finding Mission on Myanmar, known as FFM, that reasonable grounds existed to conclude that gross human rights violation amounting to serious international crimes had been committed in Myanmar, including in Kachin, Rakhine, and Shan states. The UN General Assembly subsequently welcomed the decision to create this mechanism. Bangladesh has continued to provide support to IIMM. This is yet another clear indication of the Bangladesh government's commitment towards international justice and accountability for the Rohingya. Let me conclude this section by citing Bangladesh's current ambassador in The Hague, in the Netherlands, Mr. Riaz Hamidullah, who is permanent representative to the ICC. At the 21st session of the Assembly of State Parties to the Rome Statute on 6th December 2022, just a couple of days back, he stated, and I quote, "Bangladesh has done far more than she could. Beyond humanitarian support, the Rohingyas foremost need political support. In the world, if the world is to ask for justice for the Rohingya people, all matters related to their identity. Rights in Myanmar must be addressed to pave ways for sustainable return. International justice mechanism must not ignore the Rohingya people." In closing, the ambassador, and I quote, underscored that Bangladesh values ICC as a living institution in ensuring global peace and stability. So we can see that Bangladesh's commitment to the UN system and its institution is unquestionable. Let me now move to the next section, which is to do with rights under regional laws. Rights for refugees, I mean. In its 8th session held in Bangkok, the Asian African Legal Consultative Organization, of which Bangladesh is a member, adopted a set of principles known as the Bangkok Principles on the Status and Treatment of Refugees. And this was in 1966. These principles are still regarded as one of the most influential formulations in the area of refugee law. The Bangkok Principles require member states to provide asylum and to preserve the principle of non-refoulement. Bangladesh's position is clear. It preserves this important and well-established principle, and it has become this principle has become an essential element of its own refugee protection framework. Moving to the next section, which is contextualizing the present refugee scenario. At a time when even the developed countries around the world are generally hesitant to open up their borders to refugees and asylum seekers for reasons such as internal security and sovereignty, Bangladesh has undoubtedly set an outstanding example of unconditional solidarity by accepting the Rohingya refugees over the last few decades. The government of Bangladesh, along with other key players, such as the UN agencies, national and international NGOs, have come a long way in their efforts to give the refugees some semblance of existence that they deserve as human beings. However, any discussion of what Bangladesh has done and what more it can do for the Rohingya living within its border must take into account the fact that Bangladesh, as a least developed country, to graduate to be a developing country, has limited resources and its own set of unique challenges. Thus, countries with greater financial and geopolitical strength can and should play a more critical role, not only by assisting Bangladesh in its support for the Rohingya, but also by opening up its own borders to the Rohingya. Other countries must not forget their obligations under the principle of international solidarity and responsibility sharing, which is enshrined in some of the key global legal instruments mentioned above, such as the 1951 Refugee Convention and the Declaration on Territorial Asylum 1967. In essence, this principle of international solidarity and responsibility states that the issue of refugee is a concern of the international community rather than a problem of individual states, and that each state is obligated to share responsibility for finding a long-term solution for these distressed communities. In the wake of the Ukraine-Russia conflict and global economic fragility, international solidarity and responsibility sharing for the Rohingya has become even more important. According to numerous reports, humanitarian aid insiders believe that the overwhelming focus of donors on Ukraine has come at the expense of other humanitarian crises, including the Rohingya. Head of partnership at ActionAid Bangladesh revealed in a recent interview that donors, including the UN, have already informed them that they should expect a 20 to 30% drop in funding for the Rohingya response next year due to lack of funds. It is important to note here that the UNHCR has also lowered its funding expectation for the Rohingya in Bangladesh in 2022. The Rohingya Refugee Crisis Joint Response Plan 2022 requested $881 million to assist the Rohingya population, has only received $378 million so far, which is only 43% of the requested amount. Whereas in 2020-2021, the JRP, the Joint Response Plan, requested $943 million and received $682 million, 72% of the requested amount. There is a clear and urgent need for stronger economies to band together and make funds available for the Rohingya. Against this backdrop, let me offer the following three significant policy initiatives by key actors to pursue and implement. First, creating a comprehensive national legal policy. And second would be improving access to education and livelihood. And the third will be addressing challenges of voluntary repatriation. But let me just the first one, creating a comprehensive national legal and policy framework. Formulation of an effective national legal and policy framework for refugee can assist Bangladesh in protecting the right of refugees and asylum seekers in a more organized manner. Such a framework will help us to align our laws and policies in line with international refugee law regime. And I don't necessarily mean that we have to become a signatory to the 1951 Refugee Convention and its protocol. It can be done without doing that. As a signatory to the New York Declaration, Global Compact on Refugees, and a member of the Global Refugee Forum, a comprehensive legal and policy framework which will enable Bangladesh to showcase its own contribution to refugee discourse, and which is quite, and I believe it is substantial and not to be underestimated. The legal and policy framework can prioritize certain areas such as education and livelihood, health, protection, and repatriation. Let me here now highlight two areas: education and repatriation. Improving access to education. In order to fulfill the spirit of Article 17A of the Constitution of Bangladesh, a pragmatic and forward-looking legal and policy framework needs to be formulated and implemented. Bangladesh will go a long way to fulfill its obligation under the SDG 2030 agenda and the Global Compact on Refugees if certain legal and policy barriers are removed. This will enable the Rohingya children and youth to access education and livelihood activities, to have a meaningful existence in Bangladesh, and then later in Myanmar when they are repatriated. Because the alternative is quite horrific. Because if this is not provided, we will then end up with not just one lost generation, but probably a few lost generation, and that would be an immense danger for all of us in this country and in the region. Let me move on to the last but not the least point that I want to touch upon: addressing challenges of voluntary repatriation. Voluntary repatriation of Rohingya to Myanmar has always been the top priority for Bangladesh. This should also remain in the forefront of the international agenda. The obligation under the fourth key objectives of the Global Compact on Refugee needs to be highlighted. And the fourth key objective is to support conditions in countries of origin for return in safety and dignity. So this is something that needs to be highlighted. The Rohingya have a right to return to their homeland, and the international community has to ensure that conditions in Myanmar are conducive for their voluntary, dignified, and safe return. The international civil society will have to constantly act as a pressure group to remind the world leaders of their obligations under the principle of international solidarity and responsibility sharing. Bangladesh will also have to continue with its proactive diplomatic effort as it is doing now, which will not only enable a safe and dignified return of the Rohingya to Myanmar, but garner international support and cooperation to achieve the objectives of international justice and accountability. Ladies and gentlemen, to conclude, Bangladesh's response to the Rohingya crisis has been exemplary under the visionary leadership of Prime Minister Sheikh Hasina. Despite numerous challenges, including limited resources, the government of Bangladesh deserves high praise for its tremendous effort and success in sustaining the lives of the Rohingya. We have indeed set a high standard for other refugee hosting countries. However, I feel that we also need to look ahead and take some bold steps which will avert future challenges and crises. As a nation, we have often proved our critics wrong, and I'm confident that we can do it again. Thank you very much, ladies and gentlemen. Thank you very much.